Hello, welcome to day one of a 2-day webinar series where we take a look at some of the trends to look out for in the affiliate and partner marketing space in 2023. So my name is Rob Davidson, Head of Content over at Awin, and I'm going to be your host over the next couple of days where I'll be speaking to a selection of colleagues from across our business about these industry trends. Thanks so much for joining us today as we take a look at the state of tracking and regulation in the industry and discuss some of the things that marketers may want to be aware of in the coming months. I'd also like to thank our guest speakers for appearing on today's panel. So, as some of you, the eagle eyed amongst you, may have noticed, we have had a late change in who's actually featured on today because Isla, who is our head of legal, has had to pull out just at the last minute. However, I'm pleased to say that in her absence, we get double the value from her legal team's expertise, with Sue and Assad joining us as well. So, to kick things off, let's start with a few introductions from the panel themselves, who are just coming up on screen right now. Assad, would you like to introduce yourself and give the audience just a quick description, I guess, of your role over here at Awin?
Of course, Rob. So it's nice to meet you, everyone. My name is Assad. I'm a senior legal counsel at Awin. I've been working here for slightly more than a year, and I deal here with a wide range of legal questions, including contract negotiations and data privacy. And I'm really happy to share my experience during this chat.
Perfect. And over to your colleague in the legal team, Sue.
Thanks, Rob. I'm Sugivandi Chinar. I have been working at Awin for 10 months now as legal counsel. Similar with Assad, I deal with main legal topics as well as negotiating, drafting, and reviewing the contracts.
Great. And finally, I'd also like to introduce our tracking expert over here at Awin, which is Stephen.
Hi, everyone. My name's Stephen Short. I've worked with Awin for about 7 years now. Initially starting in our tech support teams, moving to software engineering, and more recently, our product team. And then my main focus at the minute is how we measure and attribute sales.
Great. Well, thanks, guys, for joining us today. With those introductions out of the way, I'm just going to run through quickly the plan for today's webinar. First of all, I'm just going to provide some very top-level context around where we are right now in terms of tracking and regulation in the wider digital marketing space. So I'll run through some of the recent milestones and events that have occurred over the last few years before I then go into asking our panel a set of questions around these particular topics and really how they relate to affiliate marketing today. And that will last roughly around 30 to 40 minutes maybe, before we then finish with some questions from you, our audience. So as with you're probably all very well versed with webinar participation these days. As per usual, you'll be able to find within the chat box that you can see next to the screen a space where you can post your questions to the panel throughout the session on these topics, and we'll try to get through as many of these as we can towards the end of today's event. For those of you that can't stick around for the entire hour, we are recording this webinar, and so we will be posting it on the Awin YouTube channel once the 2-day series is actually finished, so you can find out what you missed out on the actual channel itself once that's live. But right now, let's get things underway, and I'm just going to go to this a fairly condensed overview on how things have really progressed over the last few years in terms of major updates to the tracking and regulating or regulatory space in digital marketing. Most of these milestones you're probably familiar with. I think it's worth putting them on a timeline to show how that space has evolved more recently. So starting from that regulatory perspective, the launch of GDPR naturally serves as a good starting point, I think, for this conversation, this webinar, as it really set the standard globally for a region actually codifying how you might go about policing and protecting the collection and use of personal data by any organization. I think Once that law was set live, a lot of people waited to see who might actually be penalized by it for the first time. And one of the earliest and most high-profile casualties, I guess, was British Airways here in the UK, who were initially fined over $200 million by the UK's Information Commissioner's Office for a breach of its customers' personal data in 2019. Now, the caveat to that is that that fine was later reduced to less than $25 million, so quite substantially, but it does still remain the biggest fine, as far as I'm aware, that the ICO has ever actually handed out by that organization. So GDPR really set the standard for regulating personal data privacy around the world, but it didn't take long for other markets and regions to really emulate that. So in 2020, we saw California introduced its California Consumer Privacy Act. And in 2021, Brazil began implementing its own privacy act, the LGPD, which are amongst the more high-profile privacy acts that we've seen subsequent to GDPR. Now, also in 2021, Amazon received what remains the largest ever fine handed out under the GDPR, over $800 million for improper handling of its customers' data, though that fine is still being appealed by the marketplace inevitably. And tech giants have increasingly been a bit of a target for lawmakers, naturally, when it comes to regulating the personal privacy space. So last year, for instance, Google paid a settlement with 40 US states relating to its data collection practices around its use of their users' location data. And more recently, in quite a high-profile case, Meta were found by the Irish Data Protection Commission to have violated GDPR rules around consent within its terms of service for targeting ads at its users. Now, if we shift to the tracking space from a tracking perspective and looking across a similar window of time, it was all the way back in 2017 that Google first announced that they would be removing the use of third-party cookies in Chrome to track users. A year later, we saw what remains probably the most high-profile example of a third-party company or organization extracting personal information from an online platform without that consent, that user consent, for their own purposes, when the Cambridge Analytica scandal broke and made news worldwide. Now, Mozilla actually implemented the blocking of third-party cookies as a default in its Firefox browser in 2019. But the biggest act by a gatekeeper that we've seen so far to prevent user tracking came in 2021 with Apple's release of App Tracking Transparency in its 14.5 update of the iOS system. And that had a massive impact and knock-on effect on the likes of Meta. And they reported their first ever quarterly revenue drop in 2022, with a lot of experts inevitably speculating that ATT was a major factor and reason for this actual decline. Also in 2022, the Belgian Data Protection Authority ruled that the IAB Europe's transparency and consent framework, designed to make user consent, to kind of like manage that consent throughout the online ads ecosystem, was in fact unlawful from a GDPR perspective. Now that decision has since been appealed. Just a couple of weeks ago, the Belgian DPA actually accepted changes that the IAB have proposed for changing how the framework is implemented, and they've been given 6 months to actually enact these changes as agreed. And then finally, and quite timely, bookending our timeline, we obviously had another delay from Google relating to their removal of third-party cookies in Chrome, so this time to 2024, and I guess we'll all soon see whether or not that actually materializes. Now, what I think is interesting to note across both of these timelines is really how much has happened over the last few years in this space, and particularly when it comes to GDPR, I think the impression for a long time was maybe that once it finally launched, it had very little initial impact upon business practices, and maybe wasn't being enforced by regulators to the extent that a lot of experts had maybe expected. However, as we've seen across both of these timelines, just how there has been a series of really quite high-profile, notable judgments and fines handed out more recently, which indicate how these laws are being enacted and how a lot of businesses are starting to kind of align themselves to them. So with that all said, let's go into our questions. And Sue, I wanted to go to you possibly first, and just to provide us with a bit of overall context beyond the timeline that I've just described. To date, the two biggest recent laws that have impacted the wider digital advertising space have obviously been GDPR, but also the accompanying e-privacy directive. So can you give us a quick summary of these two laws, how they are different or distinct, and also what their relevance to an affiliate audience is of affiliate marketers?
Yes, of course. Thanks, Rob. The General Data Protection Regulation, the GDPR, was actually came into force on 25 May 2018. Before GDPR, there was this European Data Protection Directive, which was mainly about introducing, like establishing minimum requirements about data privacy and security. And it was the member states who needs to adopt this directive based on their own local laws and implementing laws. So due to progressing of technology, the Data Protection Authority of the European Union declared that EU needed a more comprehensive approach in relation to data privacy and protection. And now in Europe, we can say that data protection laws are harmonized under the GDPR. For digital industries, this is very important because of this definition of what is considered as personal data is extended with GDPR as to include anything that single out an individual but isn't necessarily overtly personally identifiable. So while an email address is obviously a personal data, this scope would include another synonymous data such as IP address or ID, order IDs. And accordingly, we conclude that tracking data is personal data, even though it is pseudonymous, meaning that it cannot be direct to a specific individual without additional pieces of data. But as these additional pieces of data are held by the advertisers and publishers, we should definitely consider the tracking data as personal data. So another importance of the GDPR is about its extraterritorial applicants. So even though the GDPR was drafted and passed by the EU, it imposes obligations onto organizations anywhere as long as they target, collect, process of personal data of the EU citizens or residents. That would mean GDPR has a big impact as it might apply to you, even if your company is not based in EU, but if you process personal data of the EU citizens, residents, or in case you offer goods or services to such people. The second biggest impact could be seen as the fines, because violating GDPR is causing extensive fines. Such as there are two tiers of penalty, the first being the 20 millions of euros or 4% of the global revenue, whichever is higher. So it is crucial for the companies to comply with its GDPR obligations, as well as establishing their positioning and roles in relation to processing of personal data. The GDPR also expanded the data subject rights. It introduced data breach notifications with strict time frames, and as I said, it is also crucial to comply with these obligations in order not to face with any fines. I would also talk about this e-privacy directive. This e-privacy directive is different than the GDPR, but it sits alongside the GDPR. The GDPR is a regulation, meaning that it applies directly to the businesses and people in the European Union, whereas e-privacy is a directive, so that each member states need to implement their own local laws, need to establish their own local laws implementing the e-privacy directive. For example, we have this TTD-SG in Germany, and UK has this privacy and electronic communication regulations. These all would mean that e-privacy laws remain unharmonized now compared to the GDPR, which is quite harmonized, and thus the rules under the e-privacy directive is determined by the individual member of states and their local laws. As a result, the requirements around cookies and similar technologies, which are quite relevant to affiliate marketing, is now subject to different requirements throughout Europe. E-privacy directive in general gives people specific privacy rights to electronic communication. The most significant part for the affiliate marketing is the use of tracking technologies, especially the cookies, and any email marketing campaigns that is taken by the affiliates. I also think that it is quite helpful if we touch base on this UK positioning. As UK is no longer part of the European Union as from 2021, there was a transition period to allow data transfers between EU and UK until June 2021. And the adequacy decision under the GDPR was then adopted by the European Commission. And now it seems like the local data protection level in the UK is equivalent to that guaranteed under the GDPR. This adequacy decision is valid for 4 years, so until 2025, unless like it is renewed for an additional year. And currently we can say that GDPR no longer applies to UK. However, UK GDPR incorporated the provisions of the GDPR, so accordingly, the UK's data protection system continues to be based on the GDPR system when UK was a member of state. And then UK fully incorporated the principles, obligations, and rights of the GDPR into its post-Brexit legal system. In relation to this e-communications, Electronic Communications Directive, UK has its own privacy and electronic communication regulations, which is also derived from European law and which implements e-privacy directive. But EU is under the process of adopting a new privacy communication in relation to this electronic communications with the regulation. But with this regulation, this wouldn't automatically apply to the UK because UK is no longer under the EU. So UK is also changing the privacy and electronic communication regulations. We understand that changes are underway, but we are not yet fully understand the application impact of these changes on affiliate marketing yet. But once it is passed, we can see that we understand how likely it would look. It would increase fines. There will be an opt-out model for cookies, and there will likely be some sort of global overarching mechanism to cookie consent. We could also see bigger differences in future compared to the EU laws in terms of e-communications. In relation to the difference between GDPR and e-privacy directive, other than these are one being the regulation, which is directly applicable, and other being only the directive, this is like these laws are separate but also coexist. So if data privacy is considered, we can think of the GDPR regulation as being all-encompassing and broad on all aspects of data. E-privacy, on the other hand, is specifically concerned about with direct marketing and the functions of online tracking. They both address the same topic of consent in different ways. So we believe this is the most overlapping subject matter, the consent, because the main difference between the GDPR and e-privacy directive in terms of affiliate marketing is that cookies under e-privacy directive, like the use of cookies or similar technologies, almost always require consent under e-privacy directive. Whereas consent under the GDPR is only one out of 6 legal bases that would need it to process personal data. So, whereas GDPR doesn't necessarily require consent, but does require a valid legal basis for processing of personal data, cookies almost always require consent under e-privacy directive. E-privacy also doesn't define the term consent, but takes the GDPR's definition instead of this for clarifying the term consent. And this is also significant because the standard of consent necessary for GDPR is higher than under existing local laws. The key difference is that consent must be unambiguous. Mm-hmm. Another like an important difference between e-privacy directive and GDPR is that e-privacy directive also applies regardless of whether the user's data, like information, is classified as personal data or not under the GDPR. That would mean it essentially applies to gaining access to any information stored on the device or storage of such information on a device. However, the GDPR, on the other hand, applies to the processing of personal data. These distinctions would lead into affiliate marketing activities to be separated out in the same way, the first being the use of tracking technologies and cookies, and the second, processing of personal data for attribution.
Great. Well, thank you for that comprehensive overview on where we stand with the two different legal approaches there. But I wanted to ask, just as a kind of bringing us up to speed to date, kind of what you think with regard to these laws, what for you were like the biggest updates or developments that we saw occur last year, particularly around GDPR and e-privacy?
I would say one of the biggest updates could be the data transfers. It has been a big, quite hot topic since this Schrems 2 case.
So this is between the US and Europe rather than UK and Europe there?
Yeah, it is between US and EU right now.
Yeah.
But in general, GDPR prohibits transfer of personal data outside of the European Union unless there is an adequate safeguard in place. So this Schrems case is quite relevant because on July 2020, the Court of Justice of European Union published its judgment, as per which the Court of Justice invalidated the previous mechanism to safeguard data transfers between EU and US. So that would mean that was because the shortcomings in the US law, like there were so many large surveillance rights of US authorities, the data subject rights were not necessarily adequately protected via actionable processes. So this meant that another GDPR recognized transfer safeguard needed to be in place in order to conduct such transfers between EU and US. That would mean including the SCCs, the standard contractual clauses, is necessary, but these are also required that some kind of additional safeguard measures in place. So what is deemed to be adequate now is required an assessment by the data controller, the data exporter of the third party's law, and whether it complies and it is in collaboration with this adequate, whether it ensures the adequate protection under the EU law. So later, on July 2021, the new SCCs are released. This was quite important and hot topic as well because the new SCCs replaced the old SCCs, and the new SCCs had to be used in all new contracts starting from September 2021. And all existing SECs needed to be replaced by the end of December 2022 with this new updated SECs. So we believe we may not be the only one dealing with BSIC Q&A requests, SCC requests the end of last year. And we have been very busy ensuring that we have necessary safeguard in place to continue operate our network in line with the recent developments in data privacy.
Great. Well, sorry, go for it.
I would also touch base on this transatlantic data privacy framework. This is not yet issued, but we have seen a draft EU adequacy decision based on the executive order from US. So this draft adequacy decision was issued on 13th of December 2022. So we would expect this new framework in place about mid-2023 if all goes well. So we hope this new framework will provide more clarity to multinational businesses such as ours, and it will facilitate the smoother business.
Great. Well, I mean, I think you bring up a point there actually about the the multinational nature of a lot of businesses operating across the globe. And obviously these laws are only relevant or have come from the EU, but they kind of have this impact upon global supply chains, at least in terms of kind of data transfers and things like that, for instance. But the EU has arguably led the way globally, I think, in terms of regulating the personal data and consent space. And Asad, I just wanted to ask you from your perspective, are you seeing other countries generally attempt to align with the EU's laws in this space, or are they taking very different approaches? I mentioned obviously the CCPA in California. I mean, America's got this problem of having a kind of federal system, I guess, where states are taking kind of different approaches and then hoping to kind of align. But we have the LGPD in Brazil as well. So Asad, I was just wondering whether or not you see a general attempt from other regions' regulatory laws to try to harmonize with GDPR, or are they going their own way and taking their own approach?
Adoption of the GDPR, it has started the new age for data protection and privacy regulation for sure. And then we all observe this digital transformation of business operations, of consumer behavior, then the increasing role of the internet. So this all for sure escalates the amount of data business needs to process. And these factors, they trigger a lot of developments across the globe. And definitely, like, I'd like to concentrate on these examples that you have mentioned, Rob. So first of all, like when someone asks me about other laws, like Brazilian LGPD is one of the first ones, among the first ones which comes to my mind. It was adopted recently, and its enforcement commenced in 2021, as you have mentioned in the slides. And there is definitely a lot of crossover with GDPR requirements. But of course, it applies to Brazilian residents, but it has kind of a similar concept of this extraterritorial application. But still, we should also mention that there are certain differences, despite the fact that it has been inspired by the GDPR. For example, there might be different fines, the number of principles, which is quite legal stuff, number of principles and legal basis for personal data processing is also different. Yeah, but still, that's true. And if we talk about other regions, I would also mention that there are lots of developments in the US, like the Virginia Consumer Data Protection Act has been adopted recently. Then we also wait some privacy acts in other states, such as Colorado, Utah, Connecticut. This will also soon come into force. But still, we should mention that there are differences to GDPR for sure in terms of, again, fines, terminology, some other stuff. So it depends, like the answer about differences would depend on the exact law we're talking about. And then another thing is that we also rely in our work a lot on guidance published by authorities, which gives more understanding of how certain legal mechanisms will work in practice. And obviously, there is not much guidance yet, for example, for these new US laws. And we should wait and see how it will function in practice. Yeah, but I think it won't be still an exaggeration. Of course, there are always some certain exceptions, but it won't be an exaggeration to say that for those businesses that are already compliant with the GDPR, it should be quite often, it would be straightforward to comply with these local laws. So yeah, hope this answers your question.
Yeah, I hope so too, because it does seem an incredibly fragmented and fractured kind of approach in terms of that regulation. So I think that if GDPR is hopefully still setting that relative benchmark and it's making it easier for businesses to kind of continue to practice across the world, then that's only a good thing. Stephen, I wanted to turn to you now and to kind of take, I guess, that context from a legal perspective and just ask you a bit about how these laws have affected the way that Awin handles its own tracking setup? I think I've already spotted a few questions about that within the audience chat already. So yeah, I don't know what your take on that necessarily is.
Yeah, I guess we're in a fortunate position in the channel in that we are inherently data light. We just care about attributing the sale or the influence of a sale between two websites. So we don't necessarily care about the fine-grained characteristics of the consumer that's making the sale. And we know that's not the case across all channels. So for many years now, I think predating GDPR back in 2018, we've asked partners to collect consent for Awin. So from a broad perspective, not a great deal, but what has been welcome, at least from my perspective, is it feels with each passing ruling and finding from these courts, these local data protection authorities, it feels like we're getting a narrower and a clearer idea of what is expected from a company to process data in digital advertising. So it's helpful for our partners, I think, especially when working with other channels. And for us, on a tactical level at least, it's helpful to inform your product strategy. So what tools and products can we build to ease the burden of running a marketing campaign in 2023? And you've seen products that have come out with like the Awin consent signals tool, which has essentially come from that insight. So, but broad strokes, we've always looked to do the most we can with what little data we need, and that strategy remains.
Great. So from a product perspective, it is this kind of philosophy of privacy by design, ideally. And you just mentioned the consent signals approach, or the kind of product there. And could you explain a bit about what that is and how it works to support compliance with these laws?
Yeah. So Awin consent signals is a really simple way for both advertisers and publishers to inform Awin of Awin's consent status with the consumer. So it was really important for us to create a mechanism for publishers and advertisers to inform us of consumer consent status, so that we could take that burden essentially and react to changes as they're happening on behalf of clients. So we can use those new insights, the guidance from the industry, to track sales the most effective way we can. So the opposite stance to perhaps building the Awin consent signals tool would have been asking partners to conditionally load our tracking tags, or to conditionally make links, affiliate links, or not based on consent. But we don't want to do that. Instead, we say, tell Awin what the consumer's consent status is with us, and we'll do the rest. So an example of where that strategy has paid off would be with our sort of strictly necessary cookies for incentive publishers. So with the latest guidance from data protection authorities, we were able to exclude these publishers from consent requirements because the affiliate cookies are strictly necessary to deliver that service for the consumer for cashback and some voucher code discount publishers. So that's exactly why we built consent signals. Let's take the burden from our partners and be able to react fast to these changes as they're coming out based on the latest guidance. So specifically, we were able to get this exception for cashback and voucher code publishers.
Great. Now, what's the current status of Awin's inclusion in the IAB's transparency and consent framework? Because that was something obviously I mentioned in that milestone around tracking. We had that decision from the Belgian authority there, and they're now kind of coming to some consensus about how that can continue to operate. How does Awin's own solution kind of fit within that context?
Yeah, it's a tricky topic. So I think the first thing to note is we are a member of the TCF Europe. There's a new TCF framework, PIN number. There's a new transparency and consent framework in Canada. So we're a member of TCF Europe. And, we had a healthy debate when we came to join the TCF about its merits. But we ultimately wanted an easy and convenient way for partners to share consent information and to use Awin consent signals. And by joining the TCF, that allows for that consistency with how some of our partners are already collecting that consent. So, I think the issues in the Belgian courts, they hadn't happened yet, but I think they were evident to a lot of people from the outset. But what we do use is the TCF as a bare metal mechanism to get consent. So there's still a ton of value, I think, in having a common medium across the internet to gather consent, and TCF is currently playing that role on the web. So I think it's important to note as well, when a consumer gives consent to AWIN, so cookie consent, information storage and access, that consent is exclusively for AWIN and exclusively on that domain for that customer. So I think a lot of the issues that have transpired with the TCF have been because of these murky waters of essentially sharing consent between vendors and across domains. But our use of the TCF is very limited in nature compared to some other players in digital advertising.
Right. And from the experience of looking at how that consent status has performed, I guess, like what kind of opt-out rates on average are we seeing for from consumers currently?
Yeah, obviously that varies greatly, but I appreciate that's not a very helpful answer. But to put a broad number on it, we do see between like 60 to 90% opt-in rates. It does vary greatly based on implementation. So, for example, we've seen one partner that iteratively experimented again and again on their consent banner, both on the messaging and the user experience, and they ended up with a really great user flow, which we believe to be compliant, and they achieved a high opt-in rate in the 90s. So I think the message there is high consent rates that respect user preferences are possible, and to get data-driven with experimentation, see what works and see what doesn't work to get those high consent rates. But the damage can be limited.
Great. Okay. I wanted to move on from talking about consent and GDPR and privacy, and back to you, Asad. So beyond talking about those particular topics, what other areas of interest do you think are going to be important for marketers generally to keep an eye on as we enter 2023?
Yeah, there's certainly several topics that I would mention, Rob.
I'm sure you could go on for hours, but yeah.
Exactly. So among them, I would mention ad disclosure requirements. So there are certain ad disclosure requirements that are being imposed by authorities in different countries, for example, in the UK and US, and these requirements, they apply when links to products use these affiliate links. And in this case, like if we simplify, publishers, they need to explain why their relationship with the brands, like the nature of their relationship, like with the brands they promote. And I would mention here that we already have some guidance on AWIN website on this topic. And then we also have a plug and play ad disclosure tool called Admission. So this is in terms of ad disclosure. Then if we talk about the EU, I cannot mention the recent really hot topic connected with DMA and DSA acts. So DMA stands for Digital Markets Act, and DSA stands for Digital Services Act. So these two acts were adopted in November 2022 on the European level. So that's quite an interesting topic. I would say, like DMA, it regulates the activities of digital companies and imposes a number of obligations on them. So now they need to ensure, for example, that end users, they can uninstall some pre-installed services, that the end users can download app stores, like alternative app stores. Besides these, there are also some positive changes for developers. If we talk about the DSA, Digital Services Act, it regulates content of online platforms. So there are now some duties connected with mitigation of risks arising from spreading the disinformation, cyber violence, some illegal content. Still, I would also mention that there are certain thresholds when we talk about the applicability of DMA. So DMA applies to so-called gatekeepers. Gatekeepers are specific companies which have these significant role on the market, and they basically fulfill a role of gateways for other business users to reach their customers. So DMA applies to such gatekeepers. This could be search engines, social network services, app stores, etc. And these companies can be identified as gatekeepers based on certain metrics, like the number of users. It should be, if I'm not mistaken, at least 45 million monthly in the EU. And then there are also certain requirements in relation to business users. I think these are like 10,000. And then there are also some requirements on the turnover, and the market capitalization. But still, these are like interesting topics. The market is discussing them, and we as a legal team at Awin are also doing our best to keep an eye on all these developments.
Yeah, I mean, it sounds really interesting. It sounds like European regulators are trying to figure out a way of trying to target, I guess, some of the
Exactly.
kind of tech giants with walled gardens that are perceived to have a degree of monopoly power in kind of industries that often they might have actually created, but now obviously are kind of they're trying to open up that competition a little bit more.
Yeah, and I even remember then that when these laws, especially the DMA, I think, was discussed, the companies were specifically mentioned, like these tech giants, in the reasoning of legislators. So yeah.
Great. Well, lots to kind of keep your eye on, I think, in the coming years ahead. But talking about tracking from a wider perspective, Stephen, and not just related to the kind of privacy aspects of it, how would you describe Awin's overall approach to kind of tracking strategy in today's climate, given all of these kind of various changes that are occurring from either kind of lawmakers or kind of gatekeepers in the form of browser updates and kind of app tracking updates from Apple?
I think ultimately we want to remove ourselves from this cat and mouse game with browsers, and we hope to do so by reducing our technical footprint on the internet. So I think you saw the launch of Bouncer's tracking. By removing ourselves from the journey, we can keep in spirit of the changes by browsers, be more privacy conscious, be more data light. And, browser vendors are seeing this. They don't want these prominent third parties to have too much visibility on the journeys of consumers around the web, which I think is an understandable vision. So we want to, again, do more with less. We also want to ease the technical burden, I think, of getting started in affiliate marketing in 2023. So both for publishers and advertisers. And I think you saw, I alluded to it earlier with the consent strategy. Ideally, our partners are going to integrate once, and we can push changes to them. So we can be responsible for the tracking innovations as they're coming out, and always have the best practice tracking in place for our partners as we're reacting to these external forces. And we have a really exciting roadmap of sustainable tracking innovations coming in 2023 and this year. So I'm really excited to share more about that when the time's appropriate.
Great. I might start to intersperse a few of the audience questions into our conversation, because actually a few mirror some of the questions that I had prepared myself. So the one that's received, I think, the most votes so far relates to Chrome, inevitably, and their apparent sunsetting of third-party cookies. So, Stephen, for you, like, what will happen, do you think? Obviously, this is quite a speculative thing right now, but when third-party cookies do eventually get forbidden by Chrome, how will Awin react to that update, and will this mean that Awin can't track any orders anymore? I really hope not.
I think you chuckled earlier, didn't you, on the timeline? It's become a bit of a joke, hasn't it? So I think this is like the third delay we've seen now. And I don't know if you saw this towards the end of last year, Rob, but in November last year, someone noticed that Google actually started moving their properties, their domain structures. So instead of like maps.google.com, it's now google.com/maps. Instead of gmail.com, it's google.com/mail. And this actually changes what first-party data Google can see. So they can start to link together okay, you've searched for a local restaurant. Now they've got that first-party data against your Google account, against your searches. So it begins to give a bit of an insight into why these delays are happening. November last year, if Google can't get it right in time, then what's happening elsewhere? Just to touch on Awin, Google are far behind the rest of the browsers. So we're talking about removing third-party cookies. We've had this issue with Safari and Firefox over the last, I think, since 2018. The basic solution, the basic tracking solution for master tag continues to function after Google. And of course, we do recommend server to server again to top that up. But the basic sort of implementation that many advertisers have is already compatible with Google. But when we talk about more sustainable tracking long term, definitely recommending the master tag too. In terms of sort of what's going to happen on the internet, I think there'll be a large number of sites in a sort of shadow internet that are no longer actively maintained, that will just stop functioning. So if I had to put my product hat on for a second, I think we'll see some sort of backwards compatibility where third-party cookies will continue to function for unmaintained legacy sites, but perhaps with like a prominent privacy warning. But we've been through these large-scale changes on the internet before. If you remember the prominence of Adobe Flash just not long ago, third-party cookies at a fundamental level are a design flaw from the early internet, and they probably should have never existed. And I do think we'll see them finally begin to go fully in 2024.
Brilliant. Well, I was going to say about server-to-server tracking on obviously advertiser program. I mean, you've talked a bit about the benefits of adopting it, and I believe we did see some real uplift off of some early kind of research that was kind of focused in on that particular topic. Can you elaborate a bit on that?
Yeah. So when we're talking about this whole data light strategy and reducing our footprint on the internet, when we ask advertisers to implement server-to-server tracking, we ask them to add a new type of cookie. So a cookie specifically for server-to-server. And this cookie is special. So the problem with cookies in general around the internet and cookies used for marketing is they tend to be script-based. They can be read by different pixels across the internet. And with that data, you can start to build a picture of the consumer's browsing habits. So they leave a trace around the internet. The server-to-server cookie is special in that it has an incredibly limited scope. So it's tied to that domain, so the advertiser's domain. It can't be used across many different domains. And it's actually tied, so only a server acting underneath the advertiser's domain, so the advertiser's server can access the cookie. So it's incredibly fixed scope in what it can do. So again, on this privacy strategy that we're going for. And I like that for two reasons. Okay, first of all, with server-to-server, browsers don't have a good mechanism to block it, right? It's all happening directly between the advertiser site and Awin server, their technology provider, Awin. So they don't have a good mechanism to block it. But more importantly, they don't have an incentive to block it, right? Because it doesn't have these same privacy connotations as third-party cookies, script-based cookies. So they lack the technical means, also the incentive to block these cookies. And when it comes to numbers, just quickly, we've conducted 2 large-scale studies now across many millions of tracking calls. And what we saw is the average uplift is around 12% of measurable sales attributed to the affiliate channel for advertisers with server-to-server. So that's 12% more sales coming through on top of an existing Awin integration when you top that up with server-to-server. So highly recommended to speak to your contacts at Awin and get that integrated.
Brilliant. Well, thanks for that. I just wanted to quickly touch on app tracking as well, because I think that's something that's going to be really key for a lot of advertisers and publishers at the moment, given the amount of traffic that is being funneled through kind of apps and platforms at the moment. So how complicated is it to enable this at Awin at the moment? And what's the incentive for an advertiser to actually do this? Because I know that in the past, there have been some conversations where sales that have been generated through apps that aren't necessarily being tracked, there's a question mark around, like, as an advertiser, do I want to actually pay for this? What do I get from that?
Yeah, I can take that. So in short, not very complex. So app tracking is not an area where I think the affiliate channel needs to, or can, or should act in isolation. So about a decade ago, Awin actually had its own mobile attribution SDK. And it really just doesn't make good sense for our partners. So it's a completely different environment to web-based tracking. So with a packaged app, releases needing to go through the App Store review process, the apps needing to stay lightweight and lean, and developers don't want multiple dependencies that do the same thing. So what we said was, let's partner with the very best mobile measurement platforms being offered today. That's what they do best. And like I mentioned, there are different challenges to mobile and web attribution. So let's work to harmonize them and play nicely across different channels within that ecosystem. And that's what I've done. And most of the time, our advertisers are already using these mobile measurement platforms that we've partnered with. So these partners are already fluent and fast in getting advertisers up and running with app tracking for Awin. So it's a really nice, simple process. On the incentive front, there's 3 angles to this. So it's worth noting that I think, first of all, the advertisers who have a transactional app are actually contractually obliged to implement app tracking for Awin as per our tracking policy. But there's benefits to this, okay? So that not only boasts, I think, fair and ethical tracking, it also increases the publisher diversity mix for an advertiser program. So what we tend to see is mobile tends to lean slightly more towards content than perhaps more of a lean towards incentive on the web. In terms of numbers, clients that integrate app tracking can see up to a 50% uplift on their program. And essentially, obviously that varies greatly depending on the advertiser, how much transactional volume they get through the app. So there's a lot of caveats here. It's good for publishers, obviously, to be fairly rewarded. It's good for advertisers because they get that increased visibility on how much is actually coming through the channel. And it's also good for customers too. So what you can often see sometimes is very fragmented user journeys where, I guess, especially for when we talk about customers using incentive methods, like cashback or voucher code, that journey needs to be tracked fully across the different mediums where they can converse, where they can check out. And it leads to a very poor user experience where perhaps the journey is not getting tracked on the mobile web. So easy to integrate, it provides better visibility on the influence of the channel, obviously fair for publishers and better for users too.
Great. There's another question that's come through from the audience actually for you, Sue, and I think you might have clarified this at the very outset of our conversation, but just to kind of go back over it, someone's asked, in the context of GDPR, are the EU and UK now aligned? And when you talk about Europe, does that include UK exactly?
Yes, we cannot say Europe includes UK as from Brexit, but we can definitely say that the GDPR has been kept in UK law as the UK GDPR because the UK, as mentioned earlier, UK has fully incorporated the principles, rights, and obligations under the GDPR into its post-Brexit system. So yes, GDPR and UK GDPR are pretty much aligned.
And then there is also an important point which was mentioned by Sue before as well, that we have an adequacy decision in place, confirming and ensuring this free data flow between the EU and UK. So, yeah.
Great. Well, I think that's probably coming up to the hour, and that's probably just about all the time that we have for today's session. So I hope that you found it a really useful and entertaining and informative discussion of a topic that can actually get quite complicated and conceptual very, very quickly, I think, on both the regulatory and on the tracking side. My thanks to our panelists for taking the time to come along and share their expertise with us. And if you'd like to reach out to any of us, then please do feel free to on LinkedIn. It's probably the best kind of environment for that, I would say. My thanks to all of you for coming along to attend today's event and participating in the conversation with some great questions. Apologies, we didn't have time to cover everything that I think was asked in there, but we've tried to cover as many of the most liked ones as we possibly could. Before we finish, I did just want to signpost some additional AWIN content that is either live right now or on its way very soon relating to trends for 2023. So as mentioned earlier, I will be back in the hot seat tomorrow at the same time for our second webinar event. This time I'm going to be joined by AWIN's Global Strategy Director, Kevin Edwards, who some of you may have noticed popping into the room just now to give me a charger for my laptop, which just kind of died halfway through the webinar there, but I'm back now, which is good. And he'll be joining us alongside Jasper Mulder as our Global Publisher Director. And this time we'll be discussing some new publisher trends to look out for in 2023, as well as any wider industry developments that we anticipate coming in the coming months. On the AWIN blog right now, and actually my colleague Maura will be able to drop a link into this article. You can read our 10 industry trends for 2023. So hopefully we can drop a link into the chat right now so that you can check that article out. Now, among those trends that we've picked out are the rise of resale and rental marketplaces this year, the possible impact of Google's partnership with the coupon code aggregator FMTC in the US, and why 2023 may be a slow year for M&A activity in the industry. So you can find out all about the other trends on the blog article there. Now, the latest episode of our podcast, AWIN Talks, is out next week as well. We spoke to a couple of industry experts to get their take on where affiliate marketing is heading in 2023. So from the agency Acceleration Partners, we had Helen Southgate join us, as well as Chris Johnson from the technology partner Intently. And they joined myself and Kevin to share their thoughts and predictions for the year ahead. Finally, I wanted to let you know that if you're keen to keep tabs on all of the latest trends and insights from AWIN, then the monthly Market Insight newsletter is well worth subscribing to. We'll share a link to the sign-up page in the chat now too, in case that's of interest to you. But for the time being, though, thanks again for joining us, and thank you to our panelists. And I look forward to hosting you, as many of you as possible, tomorrow for our second 2023 Trends event. Thank you and goodbye.